So I'm gonna try to talk very loud. Because somebody's talking really loud and I don't know who it is, but it's like, why are you so loud? So I'm gonna talk really loud. So we have agency law. I don't know if you can see it. I wrote very big. So I've created 6 steps for agency law. The thing with agency law is think of it like an umbrella. Even if you have very specific structure of a corporation, just remember that agency law can always apply to almost anything. Again, a partner is an agent of a partnership. All partners are agents of a partnership. A employee is typically an agent of the principal who is their employer. If somebody's just doing something for you for your benefit, that's an agency principal relationship. Also, if you have an LLC, the members could potentially be considered agents of the LLC. And when you're looking at a corporation, an officer is considered an agent of the corporation. A director is not. And just remember that. And remember, the principal would be the corporation. So you can always bring these principles in. Sadly, they're always available. So when you're looking at agency law, the first question you have to ask is the relationship. Is there a relationship? The most important thing to look for is the who. Is there a principal? Is there an agent? Is there a third party? That's really it. Like, who is here? Is there a relationship? Which you would know if there's a set like that where it looks like there's an agent, a principal, and a third party. It's probably going to fall into the fact that there is an agency relationship. First question, who is involved, right? Who's there? Second question brings you to authority. Like, is there some type of authority? And you know that there is if 3 things are present. One, that an agent or somebody who says he's not an agent, but somebody's acting on behalf of a principal, then you know that, yes, that you're more likely than not going to be in agency land if somebody's acting on behalf of a principal. Then you have to ask, is there control? Is this principal in control of things, in control of what he wants done, in control of the things that are being done for his benefit? Then you have to ask, was there mutual consent? Now, this one, technically, you should do a little bit more analysis. You might say, yes, there was mutual consent, but you have to always ask, was there capacity to consent? Now, remember, agency law kind of came out of a little bit of contract law principles, and contract law says that you cannot be held liable for a contract that you entered into unless there was mutual consent and there was capacity to know the nature and consequences of the contract that you were entering into based on if the person was of age, mentally competent, and could understand those things. So if you do have somebody that's acting on the benefit of the principal has control of the acts, and there is mutual consent that are able to satisfy the contract principal requirements of capacity, then you do have authority, at least at the very basic level. Then you have to look at, okay, what's the scope of the authority here? 2 main types of authority. There's actual authority and apparent authority. Actual authority is the actual authority a principal gave to the agent. Now, apparent authority is authority that it appears that was given to somebody, even if it's not true. And usually this is because the principal made it seem like this person had authority they didn't, either by his negligence, his acts, the way that he, represented himself or his business, or something that agents actually did to make it seem like he had more authority than he did. Regardless, there's only 2 scopes. One is actual authority, you're acting with the authority that you were actually given, or apparent authority, you're acting with authority you don't actually have, but people think that you have. Kind of dangerous, right? Next one's liability. I broke it into 2 sections, right? You have to ask, is this person going to be bound by the contract or bound by the acts of the agent? Are we going to hold the principal liable? Well, it depends. Is what was occurring express or implied? So that's kind of going to go towards like the actual authority. So did the principal give the agent express permission and authority to act on his behalf in this specific way that he's trying to be held liable for? If the answer is yes, you would say yes, he's going to be held liable because he expressly gave him that authority. Or if he gave him implied authority, which kind of is the whole purpose of apparent authority, implied authority is by his conduct or his words or his action or the nature of the job, or, I hate to bring it up, the trilogy, course of dealing, course of performance, or the industry trade standard. If based on any of these things, this person thought he had the ability to act or somebody else did, and he appeared to have this authority, it was implied that he had this authority, then he potentially would be bound. Now, you're wondering, well, how can somebody have implied authority even if that person didn't directly give it to him? Well, if the principal, by his words, and made it seem like he wasn't against this person because he's talked to the agent before. He never limited him, by telling him, you can't do this thing. He never said that. Or when the agent did something that the principal didn't like, he never said anything. Or by his conduct, the principal just allowed this guy to do whatever he wanted. Or when it was in conversations with contractors that he worked with, did the principal ever tell them this person can't do this or this person shouldn't do this? Or if somebody brought it up, like somebody said, hey, the agent's doing this, and he knows he's not supposed to do that, and he didn't say anything, that's going to be an example of words or conduct it's implied because you didn't do anything to stop it. So typically you're going to have more likely an issue with implied authority. And then the next one, you might have potential liability with inherent authority. There's 3 types of inherent authority. Inherent authority is kind of like apparent authority. Somebody's acting on a principal's behalf, or at least they think they are, or if people, third parties, think that they are. Now you have what's known as a undisclosed principal, unidentified principal, or you have an what's the last one? I always forget the last one. Disclosed principal. Forgot that one because that's the only legit one. Sorry, there's disclosed principal, undisclosed principal, and unidentified principal. Obviously, disclosed principal, I, agent, tell a third party that I'm working on behalf of this person. So the principal is going to be held liable for that. Or I, agent, tell you, third party, I'm working on behalf of a principal, but I don't tell you who they are. Unidentified principal. So you don't know who it is, but you know that they're there. The principal would still be held liable for that one. What about an undisclosed? That's going to be I, agent. Don't tell you, third party, that I am an agent and I'm acting on behalf of somebody else. So first, I don't even tell you there's a principal, and I tell you who that person would be. So typically in that situation, the principal, a lot of times, depending on state law, can be held liable, but the agent in this instance would also be held liable. So in inherent authority, there's only one instance where the principal may not be held liable and the agents will be held liable. In every other instance, the principal would be held liable. So that's how liability works. It's actually more simplistic than you think, see? Hope I'm not talking too fast. You can always slow me down, I think, but I'm trying to get through it quick because I feel like this is really not going to be the bulk of the analysis. This is just like supplementary. We hope, right? Now, if there's liability to a third party regarding a contract, that's typically where it comes up. If they're bound by implied or express authority because of words or conduct, or because of inherent authority, so actions by the agent. Next thing you have to look at is to get away from this or to solidify your argument is one of 3 things. So you have what's called ratification or acknowledge or affirmation. So ratification is I, principal, see that you, agent, did something that you are not authorized to do, but I was like, that's fine. I will ratify it. So that's kind of like you're adopting this contract and saying it was okay, even though you act outside your scope, I'll accept it anyway. And it's very similar to affirmation, and that's the same thing, with the exception that's implied. So I, principal, see that there's this contract happening that I didn't agree to. If I don't say anything, I just let it happen. And I'm fully aware that it's happening, and I just let it happen, right? So if you just sit there. And the last one's actually called actual knowledge. And this actually goes to the third party. If the third party knows that the agent does not have the authority to act in the way that they're acting, then because of their actual knowledge, then the principal can't be held liable because the actual third party knows this person does not have the authority to make these demands, these obligations, these promises, and he does accept anything he says because he wants to hold the principal liable. You can't do that. That's not allowed. So actual knowledge is your way to get out of liability to a third party. Then obviously you have the basic duties. So once you go through all of these things, you could also always throw in the argument. Additionally to this, we can see that the agent breached their duty. Now, there is really no duty to the principal to the agent, with the exception that they act with full disclosure to tell the agent what they need to do, and they give the agent what they need and the resources they need to do their job. That's really it, and they give them clear instructions. That's not really a duty per se. It's just your duty to collaborate and work with that person, whereas the agent, they have a duty of utmost good faith and fair dealing, and they have the duty of loyalty. So they're going to be held to be acting in good faith, that they create opportunities for the agent or for the principal and the agency relationship based on what's best for the agency relationship, which is what's best for the principal. They act on what's best for the principal. They don't act in a way that harms the principal's reputation. They don't take opportunities that should have come to the principal or the agency because of that relationship. They don't act in self-dealing. They don't do anything that would benefit themselves and harm the agency relationship at all. They don't compete with the agency relationship. They keep all the accounting separate, so they don't commingle funds, and they make sure that everything is separate so that it is up to snuff, if you will. So I always just say just those two, but really the duty of loyalty kind of encompasses competition, self-dealing. It can encompass accounting, you don't commingle funds, and disclosure of things as they come up so that the principal can make alterations if they need to. So that's the gist of it. The most important question I would say is probably the second one, and that's because sometimes it's hard to tell who the agent is and who the principal. The biggest thing is who's in control here. And that actually goes to the master-servant relationship analysis, because in the master-servant relationship analysis, it might be hard to say like who is in charge. But if you really look at who's in control of what's being done and how it's being done, that's the person that's in charge. And that's usually going to be the employer. In this instance, it would be the principal. So that's the basic of agency law. Hopefully that helped.